It strikes me, General, that you had a better argument on this score, and maybe a good argument, before Aleman Gonzalez. But after Aleman Gonzalez, it seems hard to me for you to make the case. I'm just going to read you a quote there. We held that the 1252 F1 barred orders that require officials to take actions that in the government's views are not required by the INA, and to refrain from actions that, again, in the government's view, are allowed by the INA. So wouldn't vacating the guidelines here require DHS officials to take enforcement actions that, in the government's view, are not required by the INA? Just falls with the direct language of that decision.
I don't think so, Your Honor, and I'd have 2 points. First, vacatur is self-executing. The vacatur order is affirmed by this court, or if it's issued otherwise in any court, it acts against the challenged thing, the challenged rule or order on its own, and makes it legally void. It does not require any action whatsoever. It does not on its own prohibit any action whatsoever. And second, to the extent that petitioners have been attempting to draw a distinction consistent with Aleman Gonzalez between vacatur and declaratory relief, again, I think there's no, for purposes of what would coerce or otherwise would restrain in the sense of Aleman Gonzalez petitioners, an adverse declaration saying that the guidelines, the final memorandum, has been unlawful under 1226C and 1231 certainly has at least as much coercive pressure. I think that's none, but the same amount of coercive pressure. And so if that's the case, if petitioners are saying that 1252 F1 removes all available remedies, then one, it's a very strange way of writing that provision, and two, they should come out and say it, and then say that in fact there are no remedies available whatsoever. I just don't think the vacatur declaratory relief distinction doesn't work.